presentation, or feel free to send a question in the chat. And I just want to let everyone know that the meeting will be recorded today. It may be posted. Um, it should be posted somewhere for you to review if you need to in the future. So we will begin. The Office of Open Government is a separate office within the Board of Ethics and Government Accountability. The OOG, as we refer to our office, enforces the Open Meetings Act as well as its regulations. We have a very small staff. We have Director Nicole Allen, Chief Counsel Johnny Barton, Trial Attorney Nicholas Weil, Attorney Advisor Anthony Scarbo, who is in attendance with us today, and Paralegal Specialist Ms. Kimberly Brown. You can find everything regarding the Open Meetings Act at DC Official Code Section 2571 to 2580. The Office of Open Government provides education as well as training on open meetings laws and the District of Columbia Freedom of Information Act. The primary mission of the office is to promote government openness as well as transparency. And those are our primary goals of the office. Open meeting laws are designed to give the public confidence in the decision-making process of members of a public body. Most meetings of a public body are required to be open to the public along with their decisions as well as their records. A meeting is usually defined by its purpose and the number of participants. You should ask yourself, is the purpose of the meeting to perform public business? If it is, then you have to adhere to the Open Meetings Act. If it's a social gathering, it's not considered a meeting. You also have to ask yourself, do we have the correct number of members to conduct business? Do we have a quorum? So those are two main questions that you should ask yourself at the beginning of a meeting. Meetings are presumed to be open to the public, and the public must receive advance notice of that meeting. Advance notice includes the date of the meeting, time and location of the meeting, as well as a draft agenda. A meeting is considered a gathering of a quorum of the members of a public body where the board members consider information, conduct, or advise on public business. Public business can include such things as gathering information, taking testimony, discussions, deliberations, recommendations, as well as voting. So there are a number of different things that public business includes. A meeting may be held in person, via telephone, via video conference, or other electronic means of communication. What is not considered a meeting? A chance or social gathering where no business is discussed. That's not considered a meeting. A press conference is also not considered a meeting. And if a quorum has not been met, then the public body cannot conduct a business. If you gather and you've not met a quorum, then that meeting cannot take place that day. And unless it's established by enabling legislation or mayor's orders or regulations, a quorum is a simple majority, which is more than half of the public body. Email exchanges between members of a public body do not constitute a meeting. Subcommittee meetings also are not considered meetings under the OMA, but you have to be careful with subcommittee meetings. If the number of members constitute a quorum, then you have to adhere to the Open Meetings Act. So that's a little tricky when you're dealing with subcommittee meetings. You have to be very careful. Who must adhere to the OMA? All public bodies must adhere to the Open Meetings Act. The following are considered public bodies, and that here in the District of Columbia, local school advisory teams are public bodies, government councils, and that includes the Council of the District of Columbia. Boards and commissions are also considered public bodies. Board of directors, advisory boards that take official action are considered public bodies, as well as board of trustees of public charter schools. Who are not considered public bodies, that would be a district agency, the mayor's cabinet, advisory neighborhood commissions, District of Columbia courts, and the professional staff of public bodies. And that's outside the presence of a quorum. What exactly is an open meeting? A meeting is open if the public is permitted to be physically present. The public is open if news media is permitted to be physically present, or a meeting is televised. Those are three instances where a meeting is considered open. A public body's meeting must be open to the public unless the Open Meetings Act permits closure. And we'll go into closure a little later in the presentation. Notice of a public body meeting is extremely important, and notice can be found in the DC Official Code section 2-576 that explains notice of a open meeting and the Open Meetings Act. When a meeting is scheduled, a public body must give notice. Public bodies must give as much notice as possible, but notice must be given 48 hours or 2 business days before each meeting, whichever is greater. Notice must be physically posted in the school or in the office or a place that's accessible to the public. Notice must be posted along with the proposed agenda on the public body's website or the district government's website. And the district government's website is called the Central Meeting Calendar, and it's located at open-dc.gov. If you need credentials for access to that site, feel free to call our office and we'll make sure you'll have access to that site. You must also timely post upcoming meetings and an annual schedule of meetings in the District of Columbia Register. So those are all the things you have to do when you're dealing with posting for public body, notice for public body meetings. The physical posting requirement at this time shall not apply, and that has been going on since March 11, 2020, when the public health emergency started, and it's more than likely will continue to December 31st, 2023. So currently, the posting requirement is currently waived due to the public health emergency. So the physical posting is not a concern at this point in time. Notice must include, as I stated earlier, the time of the meeting, the date of the meeting, the location, whether it's going to be virtual or in person, as well as the proposed agenda. So if these four things are not included in the notice, then notice is improper. Notice must also include the following statement. This meeting is governed by the Open Meetings Act. Please address any questions or complaints arising under this meeting to the Office of Open Government at opengovoffice@dc.gov. The following statement must be included at the end of all drafts and all final meeting minutes. So make sure that this statement is there. This is for the public to know if they have an issue or a complaint, they can contact our office to help resolve the issue. Closed meetings. Information on closed meetings can be found at DC Official Code Section 2-57B and explains the justifications for closed meetings. Notice must also state whether your public body will enter a closed meeting. It's very important. If you're going to have a closed meeting, it has to be in the notice. Notice must include the OMA citation as well as the justification for the closure. If that is not included, then you're not able to go into a closed session. Closed meeting justifications. There may be a court order or statute that mandates closure. Closure may be to discuss issues such as contract negotiations, to preserve attorney-client privilege or obtain legal advice. Those are justifications to go into closed sessions. Other justifications would be if you have to discuss trade secrets or personnel matters. Other reasons, other justifications for closure. And if the matter involves a student's personal information, it's a valid justification for going into closure. Evaluations by eligible chartering authorities, trainings for staff and board members, such as what we're doing today, justification for a closed meeting, collective bargaining negotiations, preparing a grading test, other justifications, deliberations in an adjudication action, or public safety issues, as well as plans to discuss an investigation. Those are the closed meeting justifications that you will find in the DC official code. And if you're using those justifications to enter into a closed meeting, that justification, the citation, and the deliberations or that section has to be included in the notice. And if it's not included, you're not able to move into that closed session. There is a protocol on entering closed meetings. The presiding officer will open the public meeting and establish a quorum. The public body will then conduct business in the open meeting. The presiding officer will then move to enter into a closed session. The motion to enter into the closed session must include reference to the OMA citation that justifies the closure. Another member at that time must second the motion, and the presiding member will then take a roll call vote. And if the motion passes, then you're able to enter into a closed session. So there's an open, you move, you motion, and then you take the roll call vote. and you're able to proceed into the session. You have to be careful. You're only able to discuss the matters that are referenced on the agenda. If you cite that you're going to discuss in a planned investigation, then that's all you can discuss at that meeting. If another subject comes up and it's not listed on that agenda or the notice, then you have to table that topic for another meeting. So make sure that you list every justification or every issue that you plan to discuss in the open session in the notice. Everything has to be recorded. You record what's discussed in that executive session or the closed session. All open and closed sessions are always recorded. After the closed meeting concludes, the presiding officer will reopen the public meeting and, where appropriate, report publicly any official action taken in closure and adjourn the meeting. As I stated, all open or closed meetings should be recorded. Recordings may be by audio or video recording, or you can complete detailed meeting minutes if you do not have access to the audio or video recording. You may also use a transcriber. You must ensure that there are no copyright restrictions with posting of minutes. Publication requirements, DC Official Code Section 2-578. Draft detailed meeting minutes must be publicly available no later than 3 business days after a meeting takes place. You must include a note at the top of the draft meeting minutes advising the public that detailed meeting minutes will be posted to the website on the next meeting date. Audio recordings, video recordings, and transcripts are all considered copies of the full record, and they must be available no later than 7 business days after the meeting takes place. The district requires preservation of electronic meeting records and written meeting minutes. All meeting records must be preserved for a minimum of 5 years. So please do not destroy your records for at least a minimum of 5 years. It's probably best to keep them a little longer, but you definitely have to keep them for 5 years. 3 DCMR Section 10409.8 requires compliance with district record preservation law and the District of Columbia General Records schedules concerning the disposition of its records, electronic meeting records, and written meeting minutes. A public body can meet via video conference, phone conference, or other electronic means if arrangements are made to accommodate the public. The public must be able to attend the meeting. All meetings are recorded. All votes are taken by roll call, and all provisions of the Open Meetings Act are adhered to. So electronic meetings can take place. Public bodies may allow for public comment. A public body may have enabling legislation or bylaws that mandate a period for public comment, or a public body may allow public comment absent a mandate to do so. A public body has the right to regulate the time allotted and the duration of the public comment if they choose to allow them. unless the requirement is already spelled out in enabling legislation or the bylaws. Cancellations. Public bodies may cancel meetings. A meeting cancellation is considered a change in the schedule, and the public should be notified of the cancellation. The OMA requires as much notice to the public as possible, but not less than 48 hours or 2 business days, whichever is greater, before a meeting occurs. You must establish a record of the cancellation. The meeting notice to the public must state that the meeting is canceled. This is to ensure the public you're not meeting in secret. If a public body sees a notice that you're having a meeting and they don't have access, the first thing they'll do is call our office, and then you have to go through the go through the process of trying to prove that we actually canceled the meeting and we did not have a meeting. So if a meeting is canceled, please notify the public as soon as you possibly can and document it so you'll have it for your records. Emergency meetings can take place. Emergency meetings must be called in good faith and must not be used for an excuse to circumvent the OMA. The presiding officer must open the meeting with a statement explaining the subject of the meeting, of the emergency, clearly state the nature of the emergency, and the presiding officer must explain how the public notice was provided, because notice must be given to the public at the same time that it's given to the public body. So if you're dealing with an emergency meeting, once you know that you're going to have this meeting, the public body and the public has to know at the exact same time. I want to specifically point out that emergency meetings are not special meetings. They're 2 different types of meetings. If you have, say you have 10 meetings scheduled for the year and an issue arises where you need to meet outside of the regularly scheduled meeting, then that meeting would be considered a special meeting. Special meetings occur outside of the public body's regular meeting schedule. And notice for a special meeting is also 48 hours or 2 business days prior to that meeting. Emergency meetings usually involve urgent matters where advance notice is not possible. Emergency meetings usually consist of matters that pose an immediate threat to the health and safety and welfare or destruction of property. So be very careful when you're just adding a meeting. That would just be a special meeting and not an emergency meeting. The Office of Open Government has a complaint process for the public. An aggrieved party may complain to the Office of Open Government for relief if a meeting may have been conducted in violation of the OMA. The complainant may refer to a past meeting, or the complainant may complain of a meeting that is scheduled to occur. The complainant may also submit the complaint in person, online, via mail, or by email. Director Allen at that time may seek to resolve the dispute through our conciliation process, which is included in OMA. She may decide to dismiss the complaint, issue an advisory opinion, or any other step that's permitted by the OMA and the OMA regulations. So there are a number of different things that can happen when someone complains regarding your public body. The Office of Open Government also has the authority to bring a lawsuit in the Superior Court of the District of Columbia for injunctive relief of any violations of the OMA, and that can take place before a meeting takes place or after the meeting takes place. The court may require additional forms of notice for your public body. They may postpone a meeting, or they could also declare that the action taken at a past meeting could be totally void. So there are repercussions for not adhering to the Open Meetings Act. Here's a quick little summary of what's been covered so far. A quorum triggers a meeting. If you do not have a quorum, there's no formal action that can be taken. You're required to give the public notice 48 hours or two business days before a meeting occurs. You are to physically post the notice so the public is able to view it, and you're also required to post the notice on the website. And as I stated earlier, this physical posting requirement is waived up until December 31st, 2023, due to the public health emergency. Your notice should also include the time, date, location of the meeting, virtual or in person, the draft agenda, as well as the citation to the OMA for a closed session if you plan to enter into a closed session. And you have to cite every justification that you're going to discuss on that notification. You must record all open and closed sessions of the meeting. Recordings of the public meeting must be available to the public, and that's without the need of a FOIA request. We do have a number of complaints that individuals request information and they're told that they have to go through the Freedom of Information Act, and that is not true with the public body meeting records. They are to be proactively disclosed. Draft meeting minutes. Draft meeting minutes should be posted within 3 days. Detailed meeting minutes should be posted on the next meeting date. Here we have the OMA checklist. Some of you may have already received this. I think I sent it out before. This is a very good document, a great document that you should post somewhere. And this explains in detail what needs to be done to be OMA compliant. It's like a little checklist, a little cheat sheet, step by step. It tells what you need, and it's a very good resource. I have the location on our website. It's open-dc.gov document/OMA compliance-checklist. You'll be able to find that document there if you want to print it out. I will also send this deck over after the presentation. Our contact information is here. Feel free to contact any of us. We're here to help. If you have a question, don't be afraid to ask. We are here to help you all be compliant with the Open Meetings Act. And if you see a problem or you have a problem, we are here to help you with that particular issue. I want to thank everyone for attending this training this morning, and If anyone has any questions, let's see what's in the chat. Can the meetings be held via Zoom, or is it strictly on WebEx? We do have, you can have meetings on Zoom. There are a number of public bodies that have meetings on Zoom. As long as you allow the public, give them reasonable access to the Zoom link and give them the Zoom link in the proper amount of time, 48 hours before the meeting, then that's fine. So you can have a meeting via Zoom. Okay, I see that. Thank you, Anthony. You answered that question for me. Are there any other questions that haven't been addressed? Or any questions anyone wants to unmute themselves and ask? All right.
Ma'am, yeah, this is the first time we heard that it could be, well, at least for me, that we could have our meetings on Zoom. So was that a change, or was it always like, we were told that we were restricted, so.
Yeah, Leon, this is Jackie. You're absolutely correct. I was going to put that in the chat. We will have to check with our agency. Is our agencies they want us to use Zoom? I'm sorry, Teams right now. So they have not given us the authority to use Zoom. So we will have to check with our agency.
And that's
Yes.
That's totally up to what your agency or what your public body can and cannot do. There are a number of different what we see people like YouTube, Facebook, Zoom, go-to meetings. At this time, we just recommend that whatever platform you use, that you allow the public access to that and they're able to attend your meeting. So our focus is transparency and access. As long as you're adhering to that, then that's fine.
And I may have missed it. I'm sorry. Will you be sharing this presentation with everyone?
Yes, I will
Yes.
send it over
Okay.
shortly after. I'll send it over. And if you have any questions, after this presentation that comes up, feel free to email us. We're also available to meet with you if your public body is, has a specific issue that you need to address. Like I said, we're here to help, and we want to make sure that everyone is compliant and the public has access to the meeting.
I
All
have a
right.
question on quorums.
You have a question? Sure.
Yeah. For example, if a board's composition is, say, 9 members and 2 slots are vacant, would the majority still be like 5 from that context?
So that means you have a total of 7, correct?
Well, the official legislative provision would allow 9 official seats on a particular board, say real estate commission, but 2 seats are not filled. So would that majority still be 5 of the official composition, or would it be the majority of those who are of those who are currently serving?
It would be the majority of the 7, which would
So it wouldn't be
be
the majority of the 9 that
no, right. You would have to count the majority of the 7
are currently serving.
because you have 2 vacant, right?
Right.
So, so that would be That would be 5. Yeah,
Well, if it's just 7 serving, then it would be 4.
4. I'm sorry. It would be 4. You're correct. That would be 4. Um, you're right. It would be for a simple majority, and that's 5 if you have 7 people. You don't, because you're trying to see if you have to still count the 9. Is
Yeah,
that what your question is? No, you
yeah,
would
because
go
a lot
for
of
the
times,
7.
yeah, I'm just asking because a lot of times we have side meetings and we don't want to have a quorum where we have to publicly, invite people or announce it. So just wanted to
Mhm.
make sure.
Yes, it would be 4 with that 7. And if you have, less than that, it's just a simple majority of who you have at the time.
Okay, thank you.
You're welcome. Do we have any other questions?
I'm thinking, because we get a lot of observance from your staff, from the Vega staff. So if we don't hear back, I guess we're doing okay.
Yes, if you don't hear
Because
back, everything's fine.
okay, because we've been getting quite a few, observers from Vega.
And we observe every week. It's not just your agency. We observe as many public body meetings we can a week. We all have a designated week of oversight, and we attend quite a few meetings during that particular week. It's just not your agency. So our our mission is to, you know, oversee and attend the meetings to see if we see any issues or any problems. And it's not to say we got you. It's to, okay, we see that your board needs some assistance with parliamentary procedure. Then we would contact you and say, okay, we have a training for parliamentary procedure, or we will let you know. It's not to is not to we're not trying to find any errors or any mistakes or any, but if we do, we'll just let you know and let you know how to correct it.
So far,
Uh,
so good.
so far, so good. I see another hand.
Yes, hi, this is Kevin Cyrus. I'm with OPL, and my question is, if I'm working on something that's a special event, like a symposium or a forum or something like that, do I need to adhere to these rules when my committee meets to put the event together?
Is it a subcommittee meeting, or
How do you define subcommittee?
subcommittee is not it's not the full public body. It's um like a group of people that get together to discuss things. But as I explained in the training, you have to be careful if the number of people in that subcommittee um, constitutes a quorum, then yes, you have to adhere to the Open Meetings Act. And in your question, are you creating like a symposium for the public body, or who are you creating the symposium for?
Well, it would be for the public. I mean, licensees sort of at large, because we're doing a regional thing. So it extends past DC, it goes to other jurisdictions. And then the people, it's like a convention almost. And so it involves people, the committee involves people who are not part of the DC board. They're, part of other regional boards, basically. But when we come together, there's maybe, it would be a number equivalent to maybe our board size or greater.
We can talk offline because I would need some more details on exactly like what you're doing it, who you're doing it for. Is this something that the public should be allowed to view, or is this something that it's going to be a closed session? We would have to talk offline so I can get all the details of what exactly you're trying to do. Because like I said, if it's something for the board itself, then you may have to have the open meeting first and then go into a closed session if it's a training, because I know a lot of people use the word symposium and it's really a training for staff and public body members or board members. So we can discuss that and make sure that you're doing everything properly.
Okay, thanks.
You're welcome.
I don't know how to take my hand down.
No problem.
Here we go.
Okay. I think I don't see any other questions. And Mr. Lewis, I just want to make sure that I was clear that the vacancies do not count toward the quorum. I will make sure I'm clear with you on that one.
Got it.
Okay.
Yeah,
Okay.
it's often come up. And I was just unclear. I've heard it both ways, but I think what you're saying is what we usually go with. So
Okay. And feel free to, give me a call or email and you can go over it more if you need to. Like I said, we are here to help, and we welcome the questions, and we want everyone to be compliant. So thank you for your attendance and thank you for joining me this morning. And I will conclude the Open Meetings Act training now. Take care and enjoy the rest of your day.
Thank you much.
Thank you.
Have a good one.
Thank you. You're welcome.
thank you.
Thank you.
You're welcome.